Welcome to Shepherd and Wedderburn Scots Counsel. This is the first of a series of webinars that we are producing, which we hope will provide a quick and handy guide to signing Scots Law governed documents, or documents that need to be signed in accordance with Scots Law requirements. I'm MacLeod.
And I'm Neil Cowan, and together we're going to canter through some of the basic Scottish execution requirements. This is part 1 of the webinars on signing Scots Law documents. Part 2, covering execution of Scots Law documents and counterpart, will follow soon, so make sure that you keep an eye on our website for the next instalment or watch out for our email alert when it's ready.
We regularly act as Scots Counsel on cross-border deals that involve signing Scots Law documents alongside English law ones at completion. And one of the questions that we're asked the most by lawyers in the South is, how do we sign the Scottish documents?
The rules and requirements for signing documents in Scotland are different to those in England and Wales, and this is often overlooked or forgotten on deals involving a large number of English law documents and a handful of Scottish ones.
The rules that we're talking about today are governed by the requirements of writing Scotland Act 1995. These rules confer formal validity under Scots law if a document is signed in accordance with the rules. We're going to look at the technical nuts and bolts, where the execution block needs to sit in the document, how you sign, and the information that needs to be added to the document to complete execution. We'll also have a look, or a quick look, at how you sign schedules too.
We're not going to look at what sorts of documents need to be signed under these rules. For instance, there are different rules for signing wills, but we'll cover that in part 3. This webinar assumes that you've got a document that needs to be executed in accordance with Scots law, and being neither a Scottish qualified lawyer or a lawyer, you need some help. It should also help make sense of the signing instructions that normally accompany the document that has been sent to you for signing. The best way to do this is look at a live example of who signs what, where, and when.
Let's look at page layout. Scots law documents differ from English documents because, to be considered formally valid, Scottish documents have to be subscribed.
Subscribing a document means signing below, or signing at the foot of a document if it's a one-page document. In practical terms, this means signing a document on the same page as the last line of the last clause, just below the last bit of text. And, worth noting, the last clause has to be the last operative clause of the document. The testing clause, which begins in witness whereof, is not an operative clause. So if your execution blocks start on a new page and the only text sitting above the first execution block is the testing clause, the document won't be subscribed. In this example, clause 10 is the last operative clause. Rather than putting the execution block on a new separate page, as you would if the document were English law governed, the first execution block needs to sit on the same page as the last line of clause 10. But
it's worth bearing in mind that the whole execution block needs to sit on the same page as the last line of clause 10 in this example. So if you've got two signatories signing on behalf of a company, both signatories need to sign on the same page. Likewise, if a witness is also signing, then the witness needs to sign on the same page as the party whose signature they are witnessing.
So an execution block should not straddle multiple pages. It should not start on one page and finish on another. But if you have multiple parties signing a document, provided that the first execution block has been set out as shown in this example, so that the first party subscribes, the other parties can then spill over onto separate signing pages following on from the first signing page.
For non-Scots lawyers, it can seem like a bit of a daft rule. Why does it matter that the first party signs on the same page as the last clause, particularly if the other parties can then sign separate signing pages? Well, we're not here to defend the peculiarities of Scots law execution requirements. What we can't stress enough is that getting the execution layout right for the first execution block is crucial for a Scots law document. It can be absolutely fatal if the layout is wrong. Without subscription, the document will not be formally valid.
Last point to note here, particularly for English lawyers, because Scottish documents need to be subscribed, the execution blocks also need to start before any schedules or annexes to the document. So, for example, if you've got a document that's governed by English law, but it also needs to comply with Scottish execution rules, because it might contain fixed or floating security provisions for Scottish assets, for example, then your Scots Counsel might ask you to shift the execution blocks forward from the very end of the document so that the blocks sit ahead of the schedules. It's something that you commonly see for debentures and cross-border deals with some Scottish assets or Scottish chargers. It might also be required if Scots Counsel are asked to give an opinion that an English law deed works under Scots law as well as an English law.
Let's look at signatures. Who can sign a Scottish document? Well, that depends on the type of entity that's signing. It could be an individual, a company, an LLP, a partnership, and so on. There are a number of combinations for who can sign for each entity. For example, for a company, it might be 2 directors, or a director and company secretary, or 2 authorised signatories. But to keep things simple, in most cases, 1 signatory, a director, authorised signatory, or some other office holder, if they sign with a witness, this will be sufficient for formal validity under Scots law, and that's the formulation we've used in this example.
Well, as execution block, like the one used in this example, should make it fairly obvious where to sign. Marks or initials can be used in Scotland, but if you want the document to be formally valid, in other words, capable of being relied on in court or registered at the property register, then the signature needs to contain the signatory's forename and surname, or an initial and surname. Signing Pete Mitchell is fine, but signing Pete or Mitchell on its own is not okay.
As with all good rules, there are some bonkers exceptions. These have evolved over time. The more illegible the signature, for example, the less likely it is to be challenged. Conversely, if the signature is legible and it's clear that only a forename or a surname has been used, it's more likely to be rejected. So the moral of the story is, if you're going to sign your name Steng or Bono, best make it a squiggle rather than something identifiable.
Once signed, the full name of the signatory needs to be written in beside the signature. This can be in manuscript or typed in text next to the signature, depending on how the block has been set up. The witness then needs to sign the document, preferably below the signatory, and as mentioned before, the witness needs to sign on the same page as the signatory. The same rules on signing apply for the witnesses. They should also write in their full name in the space provided, but also their address. Either a home address or work address will be fine.
Some additional information is needed to complete the document. The date on which the document is signed by the signatory needs to be added. Now, this isn't the date that everyone agrees should be the official date of the document or the date on which it takes effect. We'll cover that in the next webinar in part 2. The date that is entered into the execution block simply reflects the date that the signatory signed.
Place of signing should also be added, and it's okay just to write in the town or city. A postal address is not needed. It's also worth noting that the date and place of signing and the names of the signatory and witness details don't need to be filled in at the point of signing. This information can be added post-completion, however, they do need to be completed before a document is registered or relied on in court. And, in practice, the sooner the information is filled in the better, as it reduces the risk of the wrong information being added at a later date.
Okay, turning to schedules. If the document has a schedule, and the schedules relate to land in Scotland, the schedule has to be signed as well, even if the schedule only contains a postal address description of a property in Scotland.
A docket needs to be added at the top of the first page of the schedule, identifying it as the schedule to the document that you've just signed. In this day and age, it can seem like overkill. Why do we need to shout, "This is the schedule to the document that's just been signed," if the schedule is attached to the document? But again, we're not here to defend the rules. They were formulated back in the day before desktop word processing and document ID numbers were widely available. And to cut a very long story short, simply stating schedule or schedule 1 at the top of a page won't be enough.
Signatories have to sign the last page of the schedule, preferably below the last bit of text. Details like the full name of the signatory, date, and place of signing are not needed. Signatories need to sign, but not initial, the schedule. They should use the same signature used to sign the execution block. Put another way, or more importantly, the same signatory that signed the execution block has to sign the schedule. So if you have multiple signatories signing for one party at completion, the responsibility for signing the execution block can't be allocated to one person with another person responsible for signing the schedule. The same guy or girl has to sign the execution block and the schedule.
Luckily, witnesses don't need to sign the schedule, even if they have signed the execution block as a witness in the main body of the document. That said, if you find a witness has been over-enthusiastic and has signed the schedule, it's not a problem. As long as the correct signatory has signed the schedule, the witness's mark will simply be ignored. And, as a last point, the same rules in signing schedules relating to Scottish land also applies to maps and plans that are annexed or scheduled to documents.
That wraps things up for this introduction on signing Scots Law documents. We've tried to keep it as brief and practical as possible. It's not supposed to be an exhaustive look at Scots Law execution requirements, so if in doubt, always refer to Scots Counsel. We just hope you'll find it a handy tool to refer to when having to organise signing documents when some of those documents are Scots Law governed. As mentioned earlier, Part 2, covering execution of Scots Law documents in counterparts, will be posted soon on the Scots Counsel pages of our website. And if you'd like a copy of these slides that you can click through under your own steam without the audio commentary, please contact Neil or myself.
Thanks for viewing our webinar. Until the next one, it's goodbye from me.
And it's goodbye from him.